Just got this box in the mail today. Not a lot of information on it, and I'm going to open it up. I love surprises, especially when it comes in the mail and it looks like it'll be fun. But what happens if the surprise is quite different? What happens if the surprise relates to information you learn after somebody dies? I met with a client yesterday in which the client learned after their father died, and during the time that their father was under guardianship and conservatorship, lacking capacity, that somebody in the family had changed the beneficiary designation on the life insurance. So rather than the life insurance going to the children, the life insurance was being directed to another non-family member, somebody who wouldn't have normally received the right to receive that life insurance. Quite a surprise. Not the same type of surprise as getting a box. So what do you do when you have these types of surprises? Well, first, understand the context of what's going on. So clearly contact an attorney. In this particular set of circumstances, the fact that the individual lacked capacity, had the inability to make decisions regarding their well-being as well as their financial affairs, the ability for them to effectuate a change of beneficiary designation such that it would go from these 4 children to a third party is not a realistic expectation of somebody who lacks capacity. So you need to unwind the transaction. This can be quite complicated because the insurance company is ready to send out that money to the beneficiary. So we have to freeze that. We call it enjoining it, or getting an injunctive order to stop the insurance company from distributing to that third party. Once we've done that, we need to have an action that asks the court to terminate the right to receive by this third party and unwind that defective change of beneficiary designation, so that the change of beneficiary designation that occurred during incapacity, while the person lacked the ability, the legal authority, and the ability to effectuate that change, that gets unwound and restores it to the benefit of the named beneficiaries that existed before this wrongdoing occurred. Not simple to do, a lot of interesting moving parts, but all doable if you know the process. One of the common mistakes is waiting too long. When the money has already been distributed from the life insurance company to the recipient, the wrongdoer, it's awfully hard to unwind it because that individual often has already spent the money, or the money, is long gone, and it's very hard to recoup it. So we really want to jump on these types of elder abuse situations well before the money has been distributed, so that we can have the asset in place and fight over that asset rather than 2 fights, which is to unwind the transaction and find the asset. We want to be able to have the asset available for recovery such that once we get that court order that unwinds the transaction, the asset can become available for our client. An issue that comes up quite often, there are all sorts of facts that we want to assess in these types of life insurance beneficiary designations, but elder abuse is a massive problem in this country. And people, when they're in this particular state, are susceptible, we say vulnerable, to all sorts of manipulations that can occur. And life insurance change of beneficiaries is one of the many forms of elder abuse that we see. They are unwindable through an appropriate court proceeding, hiring the right lawyer to help you unwind that transaction. I'm Darren Findling from the Probate Pro. If you've got questions like this or want some feedback, please reach out to me at 877-YOUR-FIRM or visit us at theprobatepro.com.